Thank you very much. Welcome back to Newsfile. And in respect of this particular discussion, Judge Lowe was on the floor. But again, as we were talking, I felt, why don't we really go back to what the EC said? If you look at the point 3 of what they said, the Supreme Court said and how they understood it. They said for persons who registered with NHIA cards, such registrations were lawful at the time of registration, and the subsequent declaration of unconstitutionality in the earlier Abu Ramadan case does not automatically render them void. They quoted the court. And then they proceeded to say such a position, according to the court, would have the effect of disenfranchising the persons affected. Again, they are quoting the court. And then they now say such registration should only be deleted by means of processes established under the law. So the EC actually is saying that it will not delete them. Now, we've had some message from the offices of the EC, and the information to us is this, that they have not said that NHIA cards are not to be deleted.
Very interesting.
What they have said is that they are bound to do so through lawful process. It says that they are saying they are bound to comply with the law and can only be deleted through exhibition process. The same court said the EC is bound to comply with the law and use only legal remedies. So it looks like over there may be a little dilemma for them, that if not through the exhibition, there's no any other window for them to do it. But they have not said they will not delete.
But that's the point I'm making.
There's an element of misreporting there.
Right.
Yes. That's the point I'm making.
You know, and then in respect of the offices,
exhibition is what
in respect of the offices that have been established, what the EC is saying, and this is a message from them, okay, from their offices, they say that they are going to enforce every provision of the law. And they have given all the parties up to May 31 to submit audited accounts. They have not talked about offices. But there had been earlier discussions at IPAC that agreed that they needed to enforce all of these. Yeah. And these were long ago.
Yeah.
So
and
they are
indeed,
simply,
the office inspections had been done.
Yes, the inspections had been done long ago. In fact, even before this, this new EC boss came in. So the last point you wanted to make, so we'll wrap up on this issue.
I think that the EC itself has purged itself of
yes, but there's an order to implement. How do we implement the order? That's the problem.
That's what I'm saying. That you see, the bottom line is that the EC has been asked to do
a certain thing.
Now that duty must follow the law.
Yeah, in accordance with the law.
Yes, and they are saying that so far as they are concerned,
that's
the
law.
gives them the opportunity under the law to do that duty, and they are bound. They are committed to do it.
Is it your understanding that this is what the Supreme Court expected in its judgment?
The Supreme Court in itself, if you read the whole judgment, it's saying that by telling the EC exactly how to do it, it's like giving them direction.
Yeah, you can't.
So we are saying that use the law to achieve what we want to do.
Thank you very much. Yeah. Briefly, quickly.
Well, in my candid opinion, I'll be surprised if the exhibition process will be adequate, will be a sufficient remedy in dealing with the specific issue of the NHI cards. I'll be surprised. And I've been asking myself, I wasn't in court, whether the EC was given the opportunity to explain this.
The report is that the EC was asked whether they could identify them, the NHI cards, and it's answered in the
affirmative. So then we should they should identify them. We don't know the number, but they should identify them. Apparently in the earlier case, the Attorney General gave the impression that there were quite a lot.
Yes.
Many of them.
Yes.
Yes, so we must find ways and means of identifying them, deleting them, telling them they've been deleted openly, giving them the chance to re-register. That will be in accordance with the ruling, the judgment.
Doc, is it possible, because the way to identify them, as we know now, is to go to the Form 1A And the Form 1A is the form that you are giving when you are coming to register. And it is the form on which you indicate which identification document you are using. Whether you are using a driver's license, you are using a passport or an NHIA card. It means that the EC must go to all its offices where the registrations were done and sift through all the forms and pick out NHIA registrants. That's like near impossible.
I said at 100,000 a day to take 5 months. At 100,000 a day, which is being very fast.
It is mission impossible.
Absolutely. It would mean the election will have to be postponed. You know, but the point I was making about this whole thing is that if indeed that is what was ordered, I support what George is saying. And the EC has not said it's not prepared to delete NHIA people. It has said that, yes. There's a process. That's what I meant by the process. We have established a process under the law that we are trying to do it. You know, you may quibble with the process as Bombay is doing about finding the cards and all of that. But, you know, this is a 5-month job if you have to go that way, just to identify the cards.
Yes, but the law is that justice must be done whether the heavens come down.
But I'm making 2 different points. The first point is that they have not said they would not delete the cards.
Right.
They said we'll do it in a certain way. Now, whether you agree with that or not is a different matter.
Okay.
But assuming they had to do it, I'm not saying that administratively it will take 5 months just to do that.
That's no joke.
Now
the main problem is it's quite clear that the EC says we intend to delete the names, but you do so only within the law, meaning you use the exhibition. Don't forget that the orders also say that whoever is deleted must have the opportunity to register. Now, what they can do is to take advantage of the continuous registration to register. But this must cease 2 months before voting. Continuous registration must stop 2 months before voting so that you can go about preparing the final register.
Okay.
Practical question, will there be time to do that?
Okay. And the very final one to you, we had discussed earlier about the suggestion that you're going to cite the EC for contempt, whether you think it will work. But a bit about this. The order said, delete or clean the register to bring it in compliance with the Constitution. What that means is that because they said the continuous presence of the NHIS cadres on the register makes it inaccurate and a violation of the Constitution. The challenge process, will it be able to remove all these people out of that register? Because those people are not supposed to be on the register.
Yeah, you see, something, you know what I see basically? First and foremost, let's ask ourselves a simple question. What is the exhibition process? The exhibition process has always been there. And it only means that, yes, come and check if your name is there.
And the particulars are correct.
In the register. If somebody is dead, come and report and let's remove the person. From what we are saying, I don't know how the EC can achieve it. If they have a software can tell them that all these people register with NHIA. So when you go, there should be a list sitting there that says that, oh, you use NHIA card. So come and as it were, regularize your citizenship. So I go and come back with my passport or all the things that CI 91 says, and my name is maintained. But if you don't do that, then at a point, I get the impression that at the point when you haven't come to really do that, then they can say conveniently that you used NHIA and it's unconstitutional, therefore your name is out. That is what I see. But like
now,
I said,
but now my question is that the court says that the current register
must be
ought not to have NHIA cadres.
Yes.
On it.
So if it has to be accurate, reasonably accurate and credible, it means the register to be presented must not contain those people. Is that your understanding of the judgment?
Well, in one vein, yes. By another vein, the same court is saying that don't delete their name. If you delete their name, give them an opportunity to register.
Yes.
So at what point, which one comes first? That's
Delete
why I'm saying
first.
that, yes. That's why I'm saying that NHIA, maybe we delete, but we put your name in a list, sitting down. When you come and check, because the whole essence of the exhibition is
so
to come and check if your name. Because
you will now bring identification documents that identifies you as a Ghanaian.
Yes, because at the close of the day, something you can sit here. You registered yesterday with possibly your driving license. If you don't go and check during the exhibition, it's possible that your name is not in the register. You understand? And you could also, I mean, it means that your name
What do
is
you think about the proposal that they are going back to the court, but not for clarity, but rather to cite the EC commissioners for contempt?
Well, that would be interesting for me because you know that contempt is a discretionary remedy that the court would decide.
Right.
If the court indeed feels that the EC is not following its orders, it will cite them. I mean, it will get them for contempt. But if the EC doesn't agree, in fact, that will also help with the clarity that everybody is talking about. If we go and the court says that, well, I think that the EC is doing exactly what we asked it to do, so they are not in contempt, so be it.
Okay, thank you very much. We'll take a break here. We'll come back and deal with some matters of corruption. You're welcome back. This is Newsfile. And of course, we are in the election season, so election matters will dominate what we do. On the line is Nana Santibedieto, who is lawyer for Evans Nemakon and Abu Ramadan, who are the ones who took this matter to court. He has some inputs to make very briefly. Nana, thank you for joining us.
Thank you, Samson. Let me say hello to your panelists and your listeners.
Yes.
Just a brief comment on this issue of the process. My view is that, you know, the court did say that the EC must do its work in accordance with its established statutory procedures.
Right.
But remember that this is a constitutional matter. You know, we shouldn't forget that. And that the court itself, if you look at when it came time to give the release, it then went on to say that under the powers given to it under Article 2.2, which gives the court the power of making consequential orders and giving consequential directions in constitutional or Article 2 matters, it is making these orders. So I don't think that those orders necessarily refer to the EC's statutory procedures, which is, you know, obviously when we're talking about the exhibition and the challenge.
Sorry, what you're saying is that the court is saying do it, but do it because we have ordered you, and don't do it under any law.
The court says that. Now let's understand that when the court says that the EC can only act under law, its own order is also law.
But this order still says, do it in compliance with the Constitution and applicable law.
Exactly. The Constitution, he says that, that's what the order says. The order doesn't say do it in compliance with the Constitution.
No, do it to comply with the Constitution and the laws.
The relevant provisions of the Constitution are found in Article 42, which tells who can qualify. Let's always keep in mind what this case is about. Second, the applicable law is CI 91, which repeats Article 42 and also tells us the basis upon which you can establish your qualification to register. So that is, for that order, that is what it is talking about. We have to read the orders reasonably. Okay. Now,
Nana, hold on 1 second.
Yeah.
You're bringing a certain enlightenment to me, myself, and I'm ready to learn. And what you're saying here is that the order actually says, do what we have instructed you so that it will come in compliance with the Constitution and the applicable law. It doesn't say, go and look for an established law and use it to do the deletion.
Exactly, because, you know, the whole case of the Electoral Commission in court was that they are already doing it. The processes that they intend to undertake to do it, which they say will be in June, were laid before the court. It would have been very simple for the court to simply say, look, Abu Ramadan and Evans Nemakon, we really don't think you have much of a case. Yes, we do see that there are people on there who shouldn't be there, but the EC is already taking steps to do it. So EC, continue what you're doing. They would not have found it necessary to use the words like immediately, to delete, and to comply with the Constitution and applicable law. That is an order, a consequential order under Article 2.2, and the court can do it, and the EC is bound to take note of it now and act accordingly. And then it goes on to say that when you've deleted, give those persons who qualify, because it says in accordance with law, those who qualify a chance to re-register. Let me ask a simple question. Under the EC's own procedures that we keep talking about, is there an opportunity to re-register in the manner that the court says now? If not, will the EC take the order B and leave Order A and say that Order A must be done in accordance with its own procedures? I don't think so. The court has given orders under Article 2.2, and it says so very clearly. It is not enforcing already statutory provisions already in play and which the EC is bound to use. That is not what it is doing. It is giving consequential orders under Article 2.2, and it says this is what the EC must do. There's also a bit of background. In court, the court took pains to find out whether the EC could identify those people who use the NHIS cards, and they said yes, they could. So it makes perfect sense.
Okay.
For the court,
So Nana, what you're saying in effect is that the EC is supposed to do these deletions by what means? How exactly is it supposed to do it? Sit in its offices and just clear them off?
Yes, I say they should identify those people, delete them, publish their names so that it can give effect to the second part of the orders, which is the Order B, which says that give them an opportunity to re-register. So those
there's a suggestion that the deletion process is impractical, yes, and that the court will not make an order requiring you to do something that is impractical. Or
that is somebody's opinion.
Okay.
That is somebody's opinion. That is somebody's opinion. The court has not said it's impractical. And if the EC believes it's impracticable, you can, as you know, Samson, you can always go back to court and say that the order is impracticable to put the order into effect or comply with it, and therefore you need further direction. But the court has not said it's impractical. No. In fact, all of these people registered in polling stations, okay? Now, polling stations consist of maybe 600 people, and in some places a little more than that. It seems to me that it is not going to be that difficult, contrary to what Dr. Rekubere is saying, to identify per polling station which people there use NHIS cards, publish their names, because they've been deleted, and give them an opportunity, whether through the continuous registration process or a special registration process, to register again. I don't see any conflict at all.
So this is where you disagree with the EC. They seem to say, yes, we understand that we are supposed to delete, but we are supposed to delete through a law that already exists. And as by our understanding, the law that exists for deletion processes is the exhibition. That's what we are going to use. You say that's not what the ruling says. The judgment says. The judgment says, do these deletions. These are my orders. And make sure that the deletions will now bring the register in conformance with the Constitution and the applicable law. And on this note, you are going to cite the EC for contempt. How are you going to establish willfulness or deliberateness in disobeying the orders?
We will cross that bridge when we get to it. As for establishing a claim in court, Samson, you know, you have the evidence and you've got the means by which you can do so.
No, here is the case where the party tells you, this is my understanding. I'm not saying I will not do it, but this is my understanding. If it is the case that they had refused.
If their understanding is unreasonable in the circumstances, Samson, it cannot be a good faith undering. Okay?
So why are you not choosing the route of a clarity? Ace Ankuma says go for clarity.
That's Ace's opinion. If you go for clarity, what makes you think the court believes that their orders are not clear? What makes you think that? In any event, I don't want to, litigate my case or whatever here.
Okay,
I just wanted to bring a perspective to this issue of the processes to be used.
Right, and it was a very useful perspective. Thank you very much. A very enlightening perspective. I'm sorry, but I'm unable to move on without picking your thought on this one. You're also a lawyer.
Yeah,
he says that read the orders. Read the orders again. Take a second read of the orders. It says, do this to make sure that the register, the current register, and it says current, conforms with the laws of Ghana. It didn't say find a process which is established under law to do it. But inside the judgment, it says do it by means established by law.
Yes. So that's what I'm saying, that we are back to the same point. The EC, you see, and the court makes a very profound statement. It says that in whatever case it is, we will direct the EC where we think they are in violation of law, but will not tell them how to conduct their day-to-day activities. And it's clear. Secondly, you see, when you look at the CI 91 under exhibition, So a person entitled to be registered as a voter may object as set out in the form 7 of the schedule, a person whose name appears in the provisional register of voters on the ground that that person is not qualified to be registered as a voter. An officer has also been given opportunity, to say that no, your name is not supposed to be in the register. These are challenges. At the end of it, so I'm saying that when the officer puts a list there and says that this number of people, because they registered with NHIA card, their names are not supposed to be there. It's up to you to come and justify your citizenship and include your name.
Oh.
So
even after the court had declared these people, they are already out.
But the court is saying that until they avoid,
Okay.
they avoid
Thank you very
that.
much. Thank you. It does obviously look like we'll get beyond that point, and maybe the process of citing for contempt might bring clarity.
Yeah, of course.
Because the court
agree.
will need to prove to the court, and the court will say what its judgment is, which has not been followed. Thank you very much. Now,
This one is not going
in the next 15 minutes or so, let's go to Parliament and to Gyeeda land. We are told that money in excess of 429 million Ghana cedis is still under probe as far as Gyeeda is concerned, and the Parliament's Public Accounts Committee has problems with the state actors involved, that they are somehow deliberately not making available the people who ought to be questioned. The Agams group people, the Just Born group people, the Goodwill International, all those who owe all the sums of money as far as the Gyeeda rot is concerned. You are in the House.
You're actually a member of the committee.
Yes, a member of the committee. What is going on?
Well, Samson, let me first of all say that this is not the position of the Public Accounts Committee. It is the reportage. Yes, individuals are giving interviews that this is what they feel, but it is not a collective decision of the
official
committee.
position of PAC.
Official position. What the official position of PAC is that yes, we still want to talk to the service providers, but then we have to hear, because they are in various categories. Some have made payments, some have contested the issues, and some we haven't seen, we haven't heard from, they haven't shown up. We are saying that the important thing is that you listen to the minister's explanations first. But we have never said that we do not want to, or the minister has never said that they will not produce the service providers. Indeed, the minister hasn't got the power to say I will not produce service providers. Parliament has its procedures. We can also subpoena. Even the minister, if he decides not to come, we will bring him by law. We have that power. That is why we have powers of a high court as a committee. So that is not neither here nor there. I think that we are going through a process. We haven't finished with Gyeeda. We've asked them to bring a better particulars. We will hear them again. And at that point, when anybody we think we want to hear first hand from, we will invite them. And indeed, they don't do, it's not the minister who does the invitation. We do the invitation, and we send the invitation first of all to the ministry, and then we invite the individuals. That is why you find that district officers from various districts, sometimes you are able to bring them in. Sometimes you watched many other people that we've brought to come and explain away what the real situation is. It's something that we can do. I do not think that we have a position has been taken that no, don't produce them. I don't think so.
The suggestion in the public is that, or the impression is that the state, which claims to be fighting these people to collect our monies back, is not showing sufficient, will or zeal to collect these monies back. Why is it that it's been all this while, and still we have in excess of 4 million Ghana cedis not collected?
I think that as a person, I always say that individuals out there are entitled to the way they see things. I think that we've had cause to invite...
No, it's their money or is their money?
I know. We've had cause to invite the Attorney General on several occasions. But you are a lawyer. You know that when somebody contests a claim, it is not an easy thing. You cannot take, like the president said some time ago, you cannot take cane and just follow people and whip them and say, bring it. You must go through due process. I mean, people are now asking me questions about Woyome. I said, yes, the last time they went to court, there was a 5A. No, there was a, what's it called? Ganeshi proceedings. And the money is in some accounts they could lay hands on. The other was that take them.
Right.
That's how far we have come. And so with all other people, you do what? You go through a legal process. It's not as easy as it looks. It's not as easy as it looks. Particularly when the people are contesting. You are saying that you owe so much. The person says no. Others are saying that let's do a write-off. Because you have also done work for the state and they haven't paid. You understand? So, I mean, so many of the things are going on. But I think that the fact that we've sustained this thing shows the commitment of the government through the Attorney General to ensure that the nation is not surcharged, but shortchanged. Because really, I do not think that any president worth his thought to want to say that people should just take money from national kitty and walk away. I don't think that can be the position under any circumstances. And as a parliamentary committee from both sides of the house, we are united to ensure that whatever is due the country comes through the use of our processes. It may be slow.
Okay.
Yesterday we're doing
let me have Koku's take on this development.
Is it being suggested that because they are contesting, some people are contesting findings or whatever, they can't be summoned before the PAC?
Not at all.
Is that it?
No, not at all. We are saying that the reason why maybe money has not been collected from them is because they are contesting the figures. But that's why we are saying that we are even more interested in those people to come and tell us exactly what the problem is and why they are contesting and what their issues are.
So extend the invitation to them.
No, we have. We are saying that the first line is always listening to the minister who leads the team.
We've listened to the minister.
After that, now you invite individual service holders. And sometimes you can handle only 2 at a time because you want to do some real in-depth questioning and answering.
I will advise that you fast-track the process.
Very well. I mean, you are very
please
well.
allow him, Mrs. Stent. Yes.
Fast-track the process. Extend invitations to them to come. The minister has been there, of course.
But he
so extend. I think people want to know. This Gyeeda thing has been on for a while. Okay? And if people aren't getting answers, it appears then there's some cover-up. I'm not saying there's a cover-up. It appears. So I think you should fast-track the invitations. If they don't...
There are people who have boldly said that these were monies that were needed for election purposes and were put through these entities. And so it will be difficult to expect that the government will go collect them.
Yes, so then we find the government guilty. We indict the government. You punish them at the polls. Yeah, you punish the government. The only way you can deal with the government is to punish them at the polls, at the elections. That's how you punish them. If you can't get individuals who you assign liability to, so as to prosecute those individuals, then you punish the entirety of the government by voting it out.
There's somebody in court, Asibit, Philip Asibit of the Goodwill International.
But we are talking of 1 or 2 or 3 people. This thing was so massive that you are not talking about.
Yeah, but for people like them, because they are in court,
they are unable.
Because they are in court, you are unable to.
Okay. Yes. Doctor.
Something went wrong.
Dr. Broby, what do you make of what came out of the Parliament's committee about this Gyeeda matter? You thought that by now the monies would have been collected, even with interest?
Well, there's something that says justice delayed. It's what? Justice denied.
Justice Hastings is justice buried.
But, there has to be a halfway house.
Sure.
This country, this thing happened in 2012. We are just about to enter a new election. And I cannot think that if we are serious about these things, we'll be sitting there saying we are protecting somebody's interests and their legal rights, etc. The process can be hastened. Fast track, as Kweku calls it. But, what is being played out is all kinds of impediments being put in the way in the name of, offering people their due opportunities, etc. I think, delaying the justice, there must be a reasonable time by which cases must be concluded. When somebody decided that I chopped $20 million, it didn't take 6 months. You understand? We are talking about 4 years now. It didn't take 6 months for a commission to sit and find nothing. But that was done without anything being lost.
Mr. John.
I like that.
The problem with corruption is that if you don't deal with it quickly, that in itself encourages corruption. No, because if I embezzle 20 million Ghana cedis and I know that it's going to take forever to do it, the more people will embezzle. So it is very, very important. I mean, I agree that justice delayed is justice denied and justice hurried is justice buried. But it is, when it comes to corruption, it is important to deal with it expeditiously. Look at Buhari. I mean, he may not be able to solve all of the just corruption problems, but the quick action, the very way in which he's dealing with it is sending the right message to even people, donors who give Nigeria money, that this is a very serious person. So when it comes to corruption, you should not be delaying and so in itself.
But I agree, but we need to also firm up our institutional capacity. You see, we are talking about 2014 because the Auditor General report reached you. When did they present it to Parliament, and where are we hearing it? Until and unless they bring it to Parliament, we are incapable of doing anything.
It's a problem which is
yes.
there
and
for the whole.
I thought you put it behind us.
No. You see, so that is it.
We've tried.
But it's
still a problem because unless it comes,
the report is always done 3 years after the event.
That's the only tool you have to work with. So if you don't have that tool, what do you do?
There was a period 10 years we never had.
Yeah. So we also need to empower the Auditor General's report to be able to do a lot.
No, but the Auditor General has the powers that he's not exercising already. And we know that if these powers were exercised, we'll not get to where we are. If we were issuing the surcharges and all.
But the surcharges are there.
In a matter of 6 months, all of these matters that have come up would have been claimed long before they happened.
Something that is where I had my problems with. Because indeed, if you look through the Auditor General's report, almost every offense that has been identified, there's a surcharge in the first place.
The Auditor General, in its interactions with Occupy Ghana, was very clear. It has never issued it.
No, I can show you copious surcharges in all the reports. The surcharge, if this officer does not do this by this time, let him refund the money. Do this. It's all there. It's always part of the recommendations that they give. The point is that you see, sometimes the interesting thing is that something you are a head of an institution, or you are a chief director, and now the auditor comes and says, Chief Director, if by 3 months we can't get the root of this money, pay. And yet the law says that you should be the person imposing the sanction. So how can you impose sanctions against yourself? So those are things we need to look at if our laws must work.
What do you say to those who say that this particular Gyeeda matter, we should forget about it because
we'll never get to the bottom?
We'll never get there because these were monies for campaign that were used
Well, as for me, anybody who makes a statement like that should justify it. Because if it were for campaign, how come others are paying back? Some monies have been retrieved, isn't it?
That is so.
Yeah, so if you are saying that it's for campaign and therefore it cannot be retrieved, how come that some is being retrieved?
There was a swallow.
Maybe those be retrieved at small amounts.
but we must all be united in ensuring that these things are
expeditious actions.
Oh yes, we all agree. It's in our interest to be, but again, we need to hasten carefully, slowly, carefully.
And the Attorney General was part of the committee that prosecuted me, so she can be expeditious.
What he says is the fixation on the removal of people who registered with NHI cards, and he says that he knows some people in Ghana who are not Ghanaians who have driver's licenses. So if they had registered with NHI cards and you remove them today, they'll go back register, even though they are not Ghanaians. They'll use the driver's license on which it's been indicated that they are Ghanaians, but they are not. But in that case, you are not helping the situation.
But the scale, NHI is one because of the Attorney General's admission that was massive.
Yes, it was very massive.
That creates another.
But I agree with you. But you see, the reality of the ground is I have always said that we need institutional reforms over and over again.
That one I agree.
You can, like I said this before. Once you meet a Goro boy, whether you are Tanzanian or something, you can get a driver's license.
Yeah.
So really, and even our passports. How many times have we seen our passports being held by other nationals? So really, we need to strengthen these institutions to be able to ensure that the holder of a Ghanaian passport went through the right process and went through a quite tight system to be able to get one.
What the court suggested was a way out is to have the one ID card system and everything. Asankuma suggests that the NDC, the NPP, they are all not interested because it is a way where they help some other people to make money somehow. Is why they are not interested.
The funders of the party?
Yes. That's how to give them jobs.
Well, I would not know. In fact, I would not know, but I believe that the argument has been that it's in our interest to have one ID system. It helps in many ways. It helps to do many things.
Right.
And even for taxation purposes, it gives government a lot more money.
Thank you very much, George. This show is brought to you by Bank of Africa, strong as a group and close as a partner. MTN, welcome to the New World Star Assurance, creating smiles since 1985, celebrating 30 years of solid partnership. NIIT, bringing people and computers together successfully, and having mosquito coil. That's the best mosquito coil you can find in town. And some of you have been very excited about Dr. Jonah coming on, Mr. Jonah coming on, and also Dr. Charles Rekubrobe and the views that they have had to share. And of course, the regular panelist and pocket lawyer. Some of you say the things he said are not things that pocket lawyers do. He's demystified the judgment in your own estimation. Thank you very much. My guests have been Dr. Charles Rekubrobe, Chief Policy Analyst, Ghana Institute for Policy Options. Also is Abdul Malik Kubako, Editor-in-Chief of the New Crusading Guide newspaper. Also, Mr. Kwesi Jonah is Senior Research Fellow, Institute of Democratic Governance, IDEC, and Senior Political Scientist at the University of Ghana. Also, George Lo is MP for North Dai and Vice Chairman of the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Thank you very much. I'm Samson Anyanini. This show was produced by Sami Odami with assistance from Emmanuel Ante, Matilda Omega, and Victor Brachi, Nicholas Opuni, and the rest of the guys. Thank you. The show is repeated at 9:30 on this platform.